and I wish you all an interesting and an informative live discussion. Marina?
Hi everyone from me as well. Thank you for joining us. So we're very excited to host TaxLinked's first live event and one of many, definitely. So let me go ahead and introduce our moderator, who is a very active TaxLink member as well. Her name is Veronica Hahn, and she is an independent consultant practicing in the sphere of international tax planning. Veronica is also the author of a professional blog, taxtoday.com, which focuses on tax planning, investment, and immigration opportunities in Asia, and especially in Singapore and Hong Kong. Veronica's blog also covers topical issues such as information exchange, fight against tax abuse, and de-offshorization. After several years of practice in consulting companies of Moscow, Veronica moved to Singapore to assist Russian business expansion into Asia. And so Veronica will be moderating the panel, and she's going to introduce our esteemed panel of experts right now.
Thank you very much, Marina. Dear colleagues, welcome to the TaxLinked live panel on de-offshorization in Russia. As you know, last year Russia adopted legislation amendments aimed to fight against offshore tax avoidance. Today we will discuss the problems related to de-offshorization and possible solutions for those problems. Please meet our expert panel, Emily Yolitis, the partner at Harnis Cyprus, a leading global offshore law firm. Emily's work includes international tax structuring and planning. Emily is a founding committee member and chairwoman of STEP Cyprus and a regular speaker at international tax conferences. Her work on de-offshorization and other topics is frequently published in Cyprus and international tax periodicals. Next panelist is Marina Warwick. She is the director and founder of Alma Legal. Marina is a corporate and commercial lawyer with a master's degree in international tax, intellectual property, and internet law. She's qualified in English, Isle of Man, and Russian law. Marina is advising clients from different industries on tax-efficient and risk-mitigating structuring of ownership and management of various vehicles. The third panelist is Maxim Shvitkiy. He's the managing director of SHFM Overseas in Sweden, a business unit especially dedicated to the provision of business service in Sweden with focus on business structuring, assets protection, and immigration services. Maxim specializes in complex business solutions including company formation and registration, corporate, family trusts, or foundation setup and management. And the fourth panelist is Sergey Bezborodov, the director in the Tax and Legal Services Department of PricewaterhouseCoopers, Switzerland. Sergey is a leading expert in tax planning for Russian and Central Asian clients. He's advising many Russian high nets. Sergey also has a vast practical experience with control foreign companies rules in several countries. And we were planning to have the fifth panelist, actually, Nikki Gauder, the partner at Capstone Group, but unfortunately he is not able to attend our event today. So now let's ask our experts to introduce de-offshorization from their perspective. Emily, I guess you are the first.
Thank you, Veronica, for the introduction. I mean, obviously, the concept of de-offshorization is not a new one. The Russian example follows the global trend of governments wishing to be informed about, to repatriate, or to ring-fence their citizens' wealth. The Foreign Accounts Tax Compliance Act, otherwise known as FATCA of the United States, the CFC regulations all across Europe and the globe, the exchange of information protocols, the tax amnesties, the OECD very ambitious Base Erosion and Profit Sharing Initiative, BEPS, and most recently this Russian de-offshorization legislation are only some examples. Basically, what needs to be done is that existing structures need to rethink their logic. New structures either need to be put in place or other means of becoming compliant need to be pursued. There is no magical one-size-fits-all solution. So each structure will need very careful consideration of its own attributes and commercial logic to see whether it is sustainable and compliant with the new Russian legislation. Thank you.
Thank you, Emily, for your introduction. Marina, could you please add something to what Emily said?
I agree that CFC legislation is not a new phenomenon at all. Russia is actually quite late to join the trend, and the purpose of the legislation is widely perceived as an attempt to raise taxes. And at the same time, if you speak to advocates who litigate tax cases in Russia, their opinion is it won't achieve that purpose. So it's really, we can discuss legislation here, but in Russia, the law is often one thing, compliance is quite another, and enforcement is quite a third thing. So really, here, at this time, as lawyers, we would need to really discuss the law, which solutions are legal. In reality, of course, you can see lots of clients who would simply ignore CFC legislation and lots of other tax provisions. But I am not going to concern myself with those people. Being in the Isle of Man, of course, you get to see all sorts of structures where clients ignore Russian legislation or they don't. But we are going to focus on the compliance trend and the structures which would be compliant with the legislation. And our problem is the provisions, the new provisions are so vague, they're not actually as highly developed as in the laws of other countries. And I believe this is going to be the focus in discussion, how to interpret the provisions of the CFC legislation. The concept of beneficial own, which exists, which is an English law concept, doesn't really exist in Russian law. The definition is quite clumsy and very open to interpretation. The concept of having other means, for example, of attributing income to an entity, what those other means going to be, no answer from Russian courts yet. So this is something really that will be interesting to see whether your clients have come across dispute already, and whether at least it arose in the level of dispute with the tax authority, even if it didn't go to court. It's far too new, but certainly very interesting development.
Thank you, Marina. Maxim, what do you think about the de-Offshorization trend in Russia?
First of all, I would like to thank for the introduction you, and I fully agree with Emily and Marina on the side that the tax as an issue, it's not the first problem for Russian clients doing overseas business, but also using proper legislation of other countries to protect their interests in their home country, because sometimes we know that legal enforcement system in Russia is not so well established yet, and some other issues will arise. So that's why taxes plus legal issues could be an issue with this de-Offshorization legislation in Russia, but also there is some gossip and whispers about the date of first apply, which is now 1st of April, but something is telling us that it should be postponed to the September. It's just a gossip, but we think that it have a basis. This is what I think about de-Offshorization. Of course, for our clients, it's more important to save their structures as much as possible, I mean overseas structures, and to make good compliance with the Russian law.
I guess to save not only structures, foreign structures, but to save information about those foreign structures. Thank you very much, Maxim. Sergey, we all know that PricewaterhouseCoopers in Russia participated in creation of CFC rules. So maybe you could give us some interesting inside information.
Sergey, I can't hear you.
Yeah, we cannot hear you, Sergey. Just a second.
This way, do you hear me?
Yeah,
Is it better
yeah.
now?
Now we can
Okay,
hear you.
yeah.
Yeah, thank you.
Good. So just wanted to make a remark. I think it's completely incorrect to say that PwC helped to create the law. There was a panel of experts which consisted of certain people. There were no PwC people in this panel. There were ex-PwC experts. And to be very honest, the way I saw how the law was drafted, the Ministry of Finance prepared the drafts. They used legislation from different sources, and then the panel of experts tried to rescue it, tried to make sure that there are no extravagant mistakes. So, for example, ideas with a listed company and certain other ideas that allow that improve situation of taxpayers were brought by the executive. The whole the way how the law was drafted was completely not influenced by any of these experts, because Ministry of Finance had their own ideas, and sometimes politically driven, sometimes economically driven. So that's just a remark on your question. We had no real say in the process, but we saw the way it was happening. Maybe an overall glance at the law. Of course, it's a very complex law. I think in the Russian history, that's the first time when we have a law of this quality and of this magnitude. I would say it's one of the best written tax rules in Russia so far. Of course, there are some technical mismatches, some things that can be twisted and improved. But overall, it's a very solid piece of legislation and very well drafted. The way how to apply it, of course, we will have to see how Russian courts and tax authorities apply it. But what we tell to clients is that if clients stick to some opportunistic treatment and they hope that tax authorities and courts read the law in a positive way, positive for taxpayers, this hope may be completely unjustified, and in a couple of years, when practice develops, these hopes can be completely ruined. Therefore, structures which are designed today with a hope to get somehow exempted from these rules can really fail in the future. And this is very risky, because clients might feel that they see light in the end of the tunnel, but when in a couple of years they reach the end of the tunnel, they realize there is a wall and they cannot get back. So when we advise clients, we have to make sure that they are not in a dead-end situation, and this is very difficult. And I think we shouldn't be scared of tax authorities in the first place, because in Russia the way how they operate is pretty particular. But we have to think more of risks outside Russia, with financial intermediaries, with banks, with require compliance now. And if the client is not compliant, they might kick them out. And that's why in the first place, for example, banks will be interpreting the law. And maybe not even relying on the practice, but relying on the way the law is written. And therefore, some structures might be tainted as non-compliant by the banks even before tax authorities come. Yep.
Okay, thank you very much, Sergey. Maybe now, after a brief introduction of everyone's opinion, we could go to the questions posted on the forum recently. So one of the most significant changes in the introduction of controlled foreign companies rules into the tax code. Russian CFC rules are quite complex and they cause a lot of questions not only from taxpayers but from experts either, especially from foreign experts. The questions posted in the forum confirmed that. So the first question was, it has been suggested that an international discretionary trust in which the settlor and beneficiary demonstrate they do not influence profit distribution and have no right to revoke assets transferred to the trust might possibly escape from CFC rules. How do you think, colleagues, is a discretionary trust an option for reducing the control below the CFC threshold? Maybe Emily could give us a brief overview of discretionary trust and in which cases which rights could be reserved for the settlor or beneficiaries.
Thank you, Veronica. It's true that since the introduction of the law, we have been flooded or inundated by requests for various types of structures, not only trusts, but mainly trusts, but also other types of structures like protected cell companies or foundations or companies limited by guarantee, or insurance wrappers, which would aim to circumvent the provisions of the legislation. Obviously, there are no rules set in stone, but it is possible that the trust, which is correctly drafted, so it needs to be irrevocable with no settlor reserved powers, such as the right to replace trustees or to direct investments, with Russian residents being excluded as possible beneficiaries, could work. The drafter really needs to ensure that the settlor, being the Russian citizen creating the trust, actually relinquishes all control over the trust assets, that he's passing legal title to the trustees, and that he reserves no ability to influence decisions as to distributions. Again, with all the proposed structures, we need to ensure that what the settlor or the founder or the instructor or the policyholder or whatever you want to call him relinquishes control directly or indirectly from the structure. The surer bet that we usually advise our clients, because there is no absolutely sure bet, is to ensure commercial purpose and substance. In a country that has concluded a double tax treaty with Russia, which does exchange information, which is not on a blacklist, and that the effective rate of the foreign subsidiary is at least 75% of the weighted average tax rate that applies in Russia. So if the company is receiving only dividends, that's, I think, just below 10% that the effective tax rate should be. Or the proportion of active income of the CFC's activity is at least 80%. So there are no rules set in stone. We do think that until 2017 is reached, when we have the stick of penalties, and the Russian authorities may start looking retrospectively in 2015 as to what has not been declared, we will not be able to know the sustainability of the proposed structures, whether a trust will actually work, whether protected cell companies will work. But there are definitely solutions that are being implemented for Russian clients, and really a lot will depend on the expertise of the drafter of the instruments and the criterion of relinquishment of control of the person instructed.
Okay, thank you, Emily. Probably someone of our Russian law experts could add something. Maxim, Marina, Sergey?
Yes.
Marina?
Of course, I agree with Emily that a lot depends on what the actual provision says and how it is drafted. We are, of course, at the mercy of, ultimately, the judges, which will resolve tax disputes, and initially the first stage of the tax authorities. And how they are going to interpret the provisions that experts like Emily would draft could be quite a different matter. My problem is here that having seen litigation in completely different jurisdictions, Russia, for example, England and Wales, and the Isle of Man, I could observe that on one and the same set of facts, judges in different jurisdictions from different law schools and systems could arrive to totally different conclusions. So who is a beneficiary and who is not? Whether a particular right to benefit is actually a right to income or not could still be open to interpretation, as much as I mean, I'm not going to talk down the quality of the CFC legislation. It's actually, indeed, Sergei was right. It's probably, so far, is the best Russia has seen. But how far the tax authorities and judges are up to speed with the provisions of English law, which have been put into the Russian de-Offshorization legislation, that still remains to be seen. So, yes, definitely, by all means, it's certainly worth trying to introduce all the well-established mechanisms of divesting the client of control of this formal structure. If, for example, it is transferred to a trustee, or in the Isle of Man, one of the favored solutions, you transfer it to an insurance company in exchange for a sort of insurance policy, which is really called a wealth management bond, and that also allows to at least to some extent dispose of the question of the Russian tax residence control over that structure. Very interesting. We'll really have to see how it's going to be interpreted, but probably the first stage is, why don't we try the tried and tested means of what has withstood scrutiny in English courts and the English CFC legislation, and see where we go from there.
I see. Okay, maybe we could go to the second question, because it is very similar to the first one. What do you think about family foundations where the settlor does not have control over the company shares transferred to the foundations? Could it help Russian taxpayers to avoid CFC rules or not? How do you think, Maxim?
Actually, yes. I think that we are considering with some of the clients that the foundation and some European jurisdiction are providing such opportunity to set up the foundation as a legal entity. And after this, after the foundation is well formed already and some capital is put on this foundation as a legal entity can acquire some assets, and having a deal with the former owner of these assets with the call option to transfer these assets back to the former beneficial owner by the call option. It could be one of the options, I think, despite that there is an option of the discretionary trust with some issues. But as far as the Sweden, where am I, is not allowed to make a trust, but there is a huge opportunity to make such foundations as a legal entity with independent capital, with no owners, with no beneficiaries, etc. It should be drafted very well in the rules of this foundation, how the assets should be managed and what kind of assets should be managed. And of course, it can be a rule of not receiving the dividends from these assets, something like that. So it could be possible to arrange such kind of structure. Basically, that there is no evident link between the current CFC rules in Russia on such kind of structures, because the focus was on trust and trust as a non-legal entity structure. But if it is legal entity, as a foundation with no owners and beneficiaries, it could be an option. But sometimes it depends on what the whole structural assets the beneficiary owners have now.
Yeah. Thank you so much, Maxim. You know that some of the experts and advisors suggest to use companies registered in the countries of Eurasian Economical Union. What do you think of that, Sergey? You are aware of CFC rules of those countries, I guess.
Sergey, can't hear you again.
Again, my audio, sorry.
Oh, yeah, I told that some advisors suggest to use companies incorporated in the countries of Eurasian Economical Union.
Kazakhstan,
Yeah.
Armenia.
Yeah, exactly, to avoid CFC rules in Russia somehow. But as far as I know, some of those countries have their own CFC rules. What can you say about that?
If you allow, I answer this question and make a remark to the previous two questions. So for
Yes, sure.
I'm coming from one of those countries. I'm actually Kazakh by nationality, so I know exactly how Kazakhstan CFC legislation is working. So indeed, if you have a company in Kazakhstan, first of all, it's as highly taxed as a Russian company. That's one thing. Second, Kazakhstan has its own CFC legislation, so you cannot so easily put a subsidiary there in an offshore jurisdiction and simply block the problem of CFC. Another thing is that you have to remember that these exemptions for Kazakhstan, Belarus, Armenian companies, for some charitable structures, it's not exemption from CFC. It's exemption from tax on CFC. This means if you have, for example, a Kazakhstan company, this company in itself is still controlled. It is a CFC, but the profit of this company is exempt in Russia. Therefore, if you have a subsidiary of a Kazakh company, let's say in BVI or wherever, then I don't even care in the first place how Kazakh CFC works. What I care is that this subsidiary is still controlled for the purpose of Russian CFC, and you've got to pay tax on that and disclose it. So just putting certain exempt structure does not make the rest of the structure healthy. So I think this idea, I'm very skeptical about that, and I think the main topic for everybody is to protect their liquid assets, their non-Russian assets, because there is not much you can do about Russian assets. And if you want to protect your liquid assets, I think the last thing you do is bringing them to a country with pretty similar political and economic climate. So that's the reason I don't think this idea applies. Practically. With respect to the previous questions, I think for trust and foundations, I can give almost the same answer. We can make various hypotheses about whether discretionary and irrevocable structure works or not, but we have to admit that we are not inventing a wheel here. All these ideas, trust foundations, life insurance wrappers, DCP, whatever, they've been in the market for 20, 30 years, and they've been tested in other countries, and in many cases failed. So we are taking the same old toolbox and try to apply it to a country which yet doesn't know how to apply the rules, in the hope that it will apply. So that's why I'm a bit skeptical that the toolbox survives. The other thing, we need to think not only about the document. We can draft a trust deed or bylaws of the foundation in a fantastic way to remove all the powers, to say it's perfectly discretionary. Whether it happens in real life, I have my doubts, because in real life, Russian clients keep calling, keep communicating with the trustee, and you can't prevent them from doing that. So a document is one thing, but real life is another. I have never seen a truly discretionary irrevocable trust for a client. How can you change a habit which exists for 20 years in just 1 year? will not happen. So nothing in the law says that influence must be binding. Influence can be non-binding. Even shareholder influence on directors is not binding. So I think in a discretionary irrevocable trust, a set law or certain influence, and you cannot remove it whatever powers you exclude. So I'm not so convinced that this structure works. In the end of the day, we are not. I don't think clients can ever get a 100% solution. What they can build is a wall of defense. If they are attacked, what can they reply? And I think a discretionary irrevocable trust with all sorts of special provisions is capable. Whether there is a thicker wall, a brick wall, or concrete wall, that's another question. But I'm not so sure that these kind of structures will.
Thank you for your opinion, Sergey. If the panelists wouldn't like to add something to what Sergey said, we could go to the following question.
Okay, you could, or I could just quickly add, because I have seen
Marina.
in the man a similar phenomenon that Maxim and Sergey were talking about, the use of foundations as owners, or at least legal holders of shares in Isle of Man companies. We have actually done a fundraising project for an Isle of Man company of a new type, where even legal shareholders are not in public record. Nevertheless, the UBO found it necessary to create a Liechtenstein foundation, which in turn had an need to hold shares in that company to create layer after layer after layer of divesting of ownership of that company. And control legally was not shown anywhere. In fact, we advised the UBO to the person who provided the funding for the foundation and the company to completely not write any powers on paper. He was on the advisory board. We wrote into the articles that the advisory board had no powers to legally bind the board of directors to make decisions for the company. So this is really as far as we could go. If you have seen the breaking down of such a structure in practice, because of this, once again, one of those rubber, very stretchy provisions in the CSC legislation of factual control, not just legal control, which is what I believe Sergey was talking about, then it's all down to a matter of evidence. Apart from providing finance and some sort of ideas which directors like to pick up on and follow anyway, because they like the ideas, I could not point to factual evidence. I mean, it was all so well concealed, any sort of evidence of factual control of the UBO, of the funder. My only concern there would be Russian tax authorities still have the right to ask foundation, no right to, no beneficiaries, fine, yes, Liechtenstein, who's the founder? And you see how far you have to go through the chain to point down to the founder, to the ultimate beneficial owner. That is of the company. That is still a little bit of an open question. But I don't think we, as, for example, as drafters this side of the Russian border, say in the Isle of Man, can do much more than just use the well-established techniques and see how they are interpreted in Russian courts. And then when we have interpretation, we'll see how we can adjust our own techniques.
Yeah, thank you, Marina. Maybe we will go then to the other question. According to CFC rules, undistributed profits of the foreign company controlled by Russian tax residents can be subject to taxation in Russia. Please clarify the definition of undistributed profits. This is one of the forum members' questions, so probably someone of you could clarify what is undistributed profits.
It's a question to me.
Yeah, to you, Marina, if you want. Yeah.
Okay. All right. There are two main types of commercial companies in the Isle of Man, for example, that I most frequently use for commercial activities and for structuring, tax structuring. One is a fairly old-fashioned type, which was created as long ago as in 1931, so it's called the 1931 Act, Company Act structure. And the other one is so-called new bank vehicle, which is commonly known here as the 2006 Company Act structure. That is a peculiar type of company, more or less models on international business companies of the BVI, which actually does not even have the obligation to prepare formal accounts. So in a traditional type of company, yes, there is an obligation to prepare accounts, and you can see where the profit is and whether it has been distributed. And of course, company resolutions will show whether profit is recommended for distribution as dividends, for example. In a 2006 type of company, it's really, once again, you can't always point to the profit, and particularly undistributed profit. Well, profit in the commercial firm in accounts is really shown in the same way. You look at the financial statements. I think Sergey will very much elucidate the concept, not just as lawyers. But it's really, I don't think the question is really addressing the obligation to pay tax on the profit of that structure. I think we as lawyers actually focus on the powers of control and right to that profit by the Russian tax resident, who is very, very rarely a direct shareholder in that company which has undistributed profit. So yes, you could try to think, oh, have a look at the company accounts, here's profit, it hasn't been distributed, doesn't matter, we want to tax you on it. But the Russian tax residents will say, but I have no right to it. I have no right to this dividend. I'm not even a shareholder. So this is really where the whole chain is supposed to break down. And to be honest, and that's what we're in the business of structuring and trying to do. So yes, interesting question, but to be honest, it's not very difficult to answer it from an accounts perspective. But what is driving it is there a right to income from that company? And very often, you just can't point to the right to income.
Okay, we can see your point, Marina. Thank you. And maybe Sergey could answer another question, which is not a directly legal question. When should a controlling person to notify tax authority of the CFC? This is one of the questions from forum.
Yeah. I think the question refers to the dilemma whether it should be 20th of March 16 or 20th of March 17, right?
Yeah.
There are different ways how you can read the law. The provision says that you have to report on 20th of March of the year, which follows the year in which share of the CFC profits is attributed or is booked to the person, the Russian person. Mm-hmm. So I emphasize here it's the year in which share of the CFC profits is booked or recorded, attributed to the Russian person. And there are two ways how people interpret that. One way is to say, well, listen, the income of CFC, taxable income is attributed to the person only in a classical case in the end of 2016, 31st January 16, which means under this interpretation that the CFC reporting deadline is 20th of March 17. I'm reading it differently. There is an article saying at which date share of the CFC profits is attributed to the person. And if you read this article, then it's crystal clear that this date is 31st December 15. And based on this reading, it has to be 20th of March 2006. I know that even Ministry of Finance is struggling with that. Let's say verbally, there were some communications that they're expecting CFC reports only in 2017. But I'm not quite sure that what they meant is really the CFC notification. Perhaps they meant filing of the CFC financial statements and preparation of the tax return, which is clearly in 2017. So the real confusion is between the date when income is recognized and becomes taxable, and this is actually CFC profits minus distributed profits, and the date when share in CFC is allocated to individuals. So this is a virtual date. It happens 31st December 15. That's why I truly believe it must be 20th of March 16. But maybe in real life we'll see differences. It all depends on how Ministry of Finance in the end enables the law, when they expect it to come.
Thank you so much, Sergey. Maxim, maybe the next question is for you. As far as you're familiar with immigration programs, de-offshorization affects Russians. Lots of Russians are living overseas. How easy for the Russians give up their passports and or residency status in Russia if they wish to avoid dealing with this issue?
Yes, one of the first questions raised in accordance with these CFC rules is why we should not consider to leave Russia and to break our tax residence as a Russian tax residence and leave someone else, somewhere else, in Europe, in Asia, or whatever. So in this issue, I'm advise my clients to analyze overall issues with moving family from Russia to another country, and also test the local new country legislation on CFC rules as well. And of course, personal taxation is also a big issue for our clients if they will receive some dividends from their assets from their operational companies. So it's a good choice to, if the people are thinking about move outside Russia and to break their tax residence in Russia. But if you still have a Russian passport, some issues may arise in the area of currency exchange of currency legislation. I mean that there is some rules adopted in Russia on the foreign accounts.
Oh, you mean monetary control legislation amendments?
Monetary control legislation, yes, and that's why. Yes, to change your tax residence could be affected or could be a positive way to avoid CFC rule, but if you have some personal accounts somewhere else outside Russia, you have to follow monetary rules because you are a Russian citizen. So to have a second passport as an option, if you have already, it's a good way, but sometimes, you know, it could be also some obligations arise because Russia is obligated to report not only second passport holders but also the holders of the permanent residence in another country to report to Russian authorities with these issues. So it could be an issue to have a Russian passport with the link to personal accounts outside Russia, but with the option that you have you are breaking your residence tax residence in Russia in case of to comply with CFC rules, it could be an option. Yes.
Okay. Thank you so much. Well, we have. Yeah. Yeah. You would like to add something? Yeah, please. If you can take on a couple of minutes. Yeah.
I actually wanted to stress that I think relocation, true relocation, is the only solution from CFC. All the rest is
Sergey, I'm afraid
people have to relocate with the entire family to create a centralized link.
Sergey, sorry, I think that you have some problems with sound because sometimes you disappear.
Do you hear me now?
Yeah.
Is it better? Okay.
Yeah.
Gotcha. I just mentioned that the relocation is the only true solution from CFC. What people have to watch out is they better move to a country which has tax treaty with Russia, because only then the certificate of residence means something to the Russian tax authorities. Otherwise, they say, well, it's a nice paper from Monaco, from Dubai, or wherever, but we don't recognize it because we don't have double tax treaty. We don't care about your central vital interest in this country. That's one thing. Second, you probably heard a rumor about citizenship, taxation by citizenship. This rumor has some basis. In fact, throughout all discussions of the Ministry of Finance of the CFC legislation, even basic, after 10 minutes, even a person who read this law for the first time in the Ministry of Finance realized that the easiest is to relocate. And in 10 minutes, everybody was saying, well, let's be like the US. Let's tax everybody by citizenship. Why Russia is worse than US? Let's use their approach. And I think in tendency, in a year or two, they are planning to change residence rules. And it also depends, of course, on the political will. But I think applying central vital interest is quite complicated. You need to look at the facts, etc., etc. I'm not excluding that Russian authorities could switch to the citizenship test, simply because it's easier to administer. And this is exactly why, if clients relocate, maybe they might think as a second wall of defense to get a second passport. Of course, they have to report it. But then at least they will be able to burn their Russian passport and get rid of the potential residence problem in the future.
Yeah, Sergey, thank you so much. I'm sorry to interrupt you, but we have a very short time left. Maybe we will have a couple of questions in the chat. Anybody? Okay, chat is silent. So Emily, I have one more question for you then. You see that CFC rules include the change of concept of the beneficial owner, which stipulates that income derived by foreign company in Russia cannot apply DTA benefits in case the company has no right to determine the economic use of that income. Is there any clarification what it means, no right to determine the economic use of the income derived in international or maybe Cyprus practice? What can you say?
Well, I can tell you a little bit about practice, but I think that this is one of the most debated concepts and has been debated for decades. What is beneficial ownership and how to determine it, and whether it is economic. Usually it is economic, but whether it is economic or not. So how Russia will interpret it is actually anyone's guess. We are seeing a global trend towards substance, obviously, and towards commercial reasoning of basing a business in a specific jurisdiction. But as we've seen, as far as Russians are concerned at least, the primary concerns are usually not tax. But actually the tax in Russia is quite low anyhow. If we consider 13% or 20%, if you move to another jurisdiction, even if you move to Cyprus, which is considered a low tax jurisdiction, and is one with which Russia has a double tax treaty, it is very likely that the tax you will end up paying as a resident of Cyprus will be much higher than you would be paying as a resident of Russia. So the concept of beneficial ownership, whether it requires substance, whether it requires both treaty partners to recognize it, what will prevail, the local legislation or the treaty, whether the treaty partners are signatories to the convention, which gives a hierarchy of rights to the treaty, whether the actual treaty partner will implement that is all a matter of debate. So I would say that the concept of beneficial ownership is not a certain one at all, and that there are various parameters that will need to be in place before someone can feel safe that they are the beneficial and economic owner and can therefore access a double tax treaty with Russia.
Thank you very much, Emily. Well, let me check once again. Maybe we will have some questions. Yep.
Hi guys, it's Masha.
Sorry, 1 minute.
There seems to be
Yes, Masha.
there is a question, a comment rather, from Panayotis, who is attending, but it seems that I cannot access it. So let me just give him, if Panayotis could maybe send it to us in the general chat window, his comment that he's made in the question area, that would probably sort out this little problem that we have. Meanwhile, please continue.
Okay, while we are waiting for the comment from our colleague attending, so maybe you have some recommendations for our foreign colleagues regarding Russian CFC rules, because I know that some Russian clients go to the foreign consultants to ask them about Russian CFC rules sometimes. What is your suggestions? Marina, maybe Emily, yeah?
I mean, the options are quite straightforward. Either you're going to disclose and you're going to pay the tax, or you're not going to disclose and you're going to take the risk that penalties will apply to you sooner or later. But it's going to be very difficult for you to find professional advisors who are going to sort of help you to break the law and not disclose. Otherwise, you're going to liquidate your structure and you're going to start anew with Russian vehicles. And we have seen some clients whose structures maybe would be more cost-effective rather than restructuring, move back to Russia actually. And there are many incentives for doing that at present because the liquidation proceeds will be exempted from tax in Russia. Or you're going to restructure into something that will be compliant with the CFC rules, but as you can see from our previous discussion, that's not always very easy and the solutions are not very sure. I mean, we've discussed them. It's either a trust or a foundation or some type of an insurance wrapper. Or you're going to move. So these are the options, and depending on the risk appetite of the client, also depending on the type of structure that they currently have in place, the cost it will take for them to change that structure and to maintain it, the annual audit, to see whether it remains compliant, because we see that the tax landscape is changing annually, if not more often, are all considerations. So there are no straightforward solutions. There are a number of options that we need to discuss, and obviously each client will need a custom advice.
Thank you, Emily. Marina, you would like to add something?
Yes, I agree as far as avoiding the application of CFC legislation is concerned. Yes, they are the basic options. But allow me to expand the question. If they want to avoid the economic effects of the application of these rules, it's really, you don't exactly avoid the rules. What I see in the Isle of Man is large companies, for example, large oil companies that used to have captive insurance companies in the Isle of Man. They are closing them down. And it's not exactly done for reasons of CFC legislation, although the obligation to disclose ownership of such structures or any right to income from such structures would be a factor. Once those captive insurance companies are on the balance sheet of a Russian oil company, which is often a public company, it often becomes a political issue. In view of the De-Offshorization trend in Russia overall, it's no longer politically correct for such a company to just have an offshore company on their balance sheet, particularly if it's a country outside the Russian tax treaty network. So for them, of course, the option of closing it down is done for other than tax reasons. more political reasons really, PR reasons, relationship with the government. So the reasons are much more diverse than simply avoiding tax. Other clients who are not particularly concerned with captive insurance, for example, financial services companies, financial brokers, sort of smaller clients, have retained their Isle of Man companies and decided to disclose and pay some tax on any income that arises from it. But for them, like Sergei mentioned, for example, asset protection and the legal means of put certain assets beyond the jurisdiction of Russian courts were probably a bit more important. There is nothing particularly illegal in creating an Isle of Man company, for example, or even opening a bank account in the Isle of Man. It's all about compliance and the willingness of the Russian tax residents to disclose, ultimately pay tax on a fraction of the income, which economically, I hear, is actually not such high a burden. It's more the question of discomfort that the Russian taxman will know about that structure at all, whereas previously they did not ask the question. So that's something I could add. Probably I saw it from experience, yeah.
Thank you so much, Marina. Unfortunately, our time is ending, so my apologies to attendees. Probably we cannot see the questions in the chat or questions section due to some technical problems, but I hope that you will add your further questions to our forum thread, and I invite our panelists to answer those questions further. I hope that we will have further discussion there. Thank you so much for participating, for sharing your opinion and giving your advices. I hope that this is not the last live session of TaxLinked, and we will see each other again.
Okay.
Thank you.
Thank you. Thank you so much.
Thank you.
On behalf of TaxLinked, I would also like to say a very massive thank you for our expert panel. Thank you very, very much for taking time out of your very busy schedules to participate. Thanks to attendees. Thanks to our content manager, Marina, for organizing this great panel. And we will be updating with the details of this event soon, and we will be letting you know on in the community on the forum. So I hope you all have a lovely rest of the day and a great upcoming weekend.
Thank you so much, Masha.
Thank you.
Thank you, Masha.
See you next time.
Goodbye.
Bye.